This is the final portion of torts or civil law, covering the areas of nuisance, intentional torts, and economic torts. We're also going to look briefly at the definitions of those, and this is also the final PowerPoint for the course. The first slide references nuisance. Nuisance can be described as an activity or condition that's harmful or annoying to others, to describe the harm caused by that activity or condition, and to describe the legal responsibility that arises from the combination of the two. We see many parts of this in schools every day. Laws of nuisance were created to have such activities cease when they unreasonably interfere with the rights of private landowners or of the general public. Following is a case called Branch Independent School District versus NL Industries. As you read through this, this has to do with a company that replaced a surface with a material that had lead in it. The school district sued, as did many districts around the country. The Texas court affirms summary judgment. A summary judgment is that given to the party suing based on the evidence alone. There's no testimony. It affirms the findings of the attorneys representing that school district. The second case noted is the City of Milwaukee versus the same industry, and the City of Milwaukee did not win in that case. It was a complete defense verdict for NL. The next slide discusses intentional torts, which are defined as any intentional acts that are reasonably foreseeable to cause harm to an individual. We saw the potential of that in a case in the previous module. Property torts involved intentional interference with the property rights of plaintiffs, such as trespassing, which is a condition that affects school districts. We'll then take a look at the case called Thing versus Lechuza. It's a 1989 case where the son of the plaintiff was injured when struck by a car. The plaintiff was close by but didn't see the accident. The plaintiff's daughter informed her of the accident. She became very distressed as a result of seeing her son bloody and unconscious. The trial court granted the defendant's motion for summary judgment. The plaintiff appealed. The majority opinion of the court seemed to set some standards because this could be a potentially runaway tort in this area. And what it defined was three different standards. One is that the plaintiff must be closely related to the injury victim. The plaintiff must be present at the scene of the time of the injury, must be aware that the victim is being injured, and the plaintiff must suffer emotional distress as a result. Because she wasn't present and not aware of the injury, even though when seeing her son on the ground, she could not recover damages, and the award was overturned. The last part of torts respond to economic torts. Economic torts protect people from interference with their trade or business, includes the doctrine of restraint of trade, but this has largely disappeared in the 20th century by statutory collective bargaining, antitrust, and competition laws. And you'll note the two cases that are here, the Mogul Steamship Limited case from 1889 and the Taffvale Railway versus Amalgamated Society of Railway Servants from 1901. Mostly the reason for that is statutory law has taken over for some years since the early 1900s. The last slide refers to some references used in the compilation of the cases and of the information on torts.